Hello guys, welcome to this MCQ series of paper 60 economic laws. My name is Ayush and in this video we are going to solve the case study number 4 from the case study digest. So let's start with the question and answers. Yes. So MCQ number 1. Within how many months the KE shall realize and repatriate the full export value pertaining to its first shipment? So for this you don't have to even refer the case study. This is a straight away question. So they are asking within how much time you should realize your export value. So 9 months is the correct answer. For those students who are not familiar with this provision, they can simply go to this legal provision sheet and they can read the legal provision. Okay, so as per regulation 9 of FEMA, in the ordinary course the amount representing the full export value of the goods, software, services exported shall be realized and repatriated to India within 9 months or within such period as may be specified by the Reserve Bank in consultation with the government from time to time from the date of export. Okay, so within 9 months you have to realize the full export value. This is taken from the page 5.58. if you have any doubt you can go to this you can directly go to this page and read more about this concept, but I have covered this concept from the as per ICAI language only. So 9 months is the correct answer. Very easy question, straight away question. And yes, question second, till which date the meeting of the committee of the creditors of KOCL shall be conducted? Okay, so as per IBC 2016, after the constitution of the COC, first meeting of the committee of the creditors shall be conducted within 7 days of the constitution of the COC. So let's see from the case study when this COC was formed. As you can see, the KOCL made a default in repayment of financial charges for the first time at the end of 2019, and NCLT ordered the initiation of CIRP on 21st Feb 2020. Okay, so CIRP was admitted on 21st Feb 2020. We have to see what was the date on which the COC was formed. Okay, so Mr. Mukund, who is an interim resolution professional, collected the claims against the corporate debtor and thereafter formed a committee of the creditors on 10th March 2020. Okay, so we have got our answer. So on 10th March COC was constituted. One among the claimant was Armax Limited. Okay, so this is not relevant. So on 10th March 2020 the COC was formed. So within 7 days of the formation of the COC, first meeting should be conducted, which is they have asked in this question. So they have asked till which date the meeting of the committee of the creditors shall be conducted. Okay, so 10th March is the constitution of COC, so 7 days from 10th March. 17th March, option B is the correct answer. 17th March 2020. Now let's go to next question. By which date KE shall submit a relevant export documents to the authorized dealer regarding its first shipment? For this we have to refer the case study. Yes, KE after reconstruction exported its first KE after the reconstitution exported its first shipment on 10th April 2020 on a credit basis to a buyer on South Africa. The date of invoice was 8th April 2020. The export documents and declarations are duly filed and in the and the name of authorized dealer is also mentioned in the export declaration. So the exact legal provision is that submission of export documents, regulation 10, the documents pertaining to the export shall be submitted to the authorized dealer. Authorized dealer means banks mentioned in the relevant export declaration form within 21 days from the date of export. Okay, so we have to ascertain what is the date of export, and within those 21 days we have to submit the documents to the authorized dealer. So here you can see that the export date was 10th April. Since here the on 10th April on a credit basis. Okay, so KE after exported its first shipment. So first shipment was exported on 10th April 2020, and 21 days from 10th April 2020 comes to 1st May 2020. So we have to see yes. So option C is the correct answer. As you can see in the given case, the export date was 10th April 2020. Hence, writing 21 days from the date of export means up to 1st May 2020. Okay, so 1st May 2020 is the correct answer. Option C is the correct answer. Question 4th. Whether making false declaration by KOCL to evade the custom duty is an offence in reference to the provisions of the Prevention of Money Laundering Act 2002. As you know, the term scheduled offence. So there are various scheduled offence which are mentioned in Offence of Money Laundering Act 2002, which are given in Part 1, Part B and Part C to the schedule. Okay, so you won't get the answer to the question unless you know what are the various offenses which are mentioned in Part 1, which are mentioned in Part B and which are mentioned in Part C. You have to know the list of offenses and the legal act under which the penalty will be made. Since KOCL has made a false declaration in order to evade the custom duty. Okay, so they have made a false declaration in order to evade the custom duty. This offense is covered in Part B of the schedule, and as per the scheduled offense, the offense specified under Part B of the schedule will be considered as scheduled offense only if the total value involved in such offense is 1 crore or more. Okay, so those offenses which are covered in Part B will be considered as a scheduled offense only if the amount involved is 1 crore or more. So in case study, what they have asked, whether making a false declaration by KOCL to evade custom duty is an offense with reference to the provisions of Prevention of Money Laundering Act. Yes, so option D is the correct answer, because false declaration under custom law is a scheduled offense if the value involved in the offense is 1 crore or more. So option D is the correct answer. Question 5th. For how many years from the date of handing over the possession of Project Nivas, the responsibility for rectifying any structural defect or any other defect is of the promoter, and within how many days the promoter is required to rectify the structural defect without any charges? So this is also a straight away questions. If you know the time period, you will know the answer directly. So this is the legal provision: duty of promoter to rectify the defects within 5 years. In case of any structural defect or any other defect in the workmanship, quality, or the provision of services, or any other obligation to the promoter as per the agreement for sale relating to such a development is brought to the notice of the promoter within a period of 5 years by the allottees from the date of handing over the possession, it shall be the duty of the promoter to rectify such defects without further charges within 30 days. In the event of promoter's failure to rectify such defects, the aggrieved allottee shall be entitled to receive the appropriate compensation. Okay, so within a period of 5 years from the date of handing over the possession, till the period of 5 years from the date of handing over the possession, promoter will be liable for the structural defects. And once the residents have identified the structural defects and informed the promoter, within 30 days of being informed, he has to rectify the defect. Okay, so within 5 years he will for 5 years the promoter shall be liable, and after being informed of structural defects, the promoter has to immediately rectify the defect within a period of 30 days. Okay, so 5 and 30 is the correct answer. That is, for 5 years the promoter has a responsibility for structural defects from the date of handing over of the possession, and within how many days he needs to rectify the same? So within 30 days of being informed about the structural defect, the promoter needs to rectify the defect without any further charge. So option C is the correct answer. So in this way we have completed our discussion of case study number 4. Thank you. Do share your feedback. Thank you.